Good evening, everyone. I note the time and I'll try and be brief. And what I'll say is a lot of what has been said is things I was going to touch on, so luckily I can skip through that. The question is, where are we today? The reality is in that no one is helping owners' corporations. And I hear the frustration in what everyone's asking tonight, and I can see nods around as well. The reality is, back in 2014, there was a fire in the docklands at La Crosse. No one did anything. The government really took no action. They put together, a bit of an inspection task force there for a bit, but it wasn't a serious response. In 2017, I remember I was actually away on holidays, and I got a call much like Jonathan did, as he described, saying, "What are your thoughts on the fire?" And I said, "What fire?" And they were obviously talking about Grenfell. For some strange reason, we know why, it was a tragic occurrence, but even though there had been a fire in 2014 in Melbourne, it took until 2017, when people died in London, for the government to actually respond and for anyone to take an interest in this issue. It shouldn't have taken that long. So I share your frustration in that. The problem we've got now, though, unfortunately, is it hasn't gotten any better. So the government, again, has tried to score political points, and I'm not attacking the government, both sides are doing it, but really cladding has become a political issue. No one is serious about helping you, though. And we see in terms of the politics that have been involved, back in the start of October, there was legislation that came out about cladding rectification loans, and some of you might have read about that and might have been excited about the prospect of being able to get cheap loans through the government or through your lender that essentially gets put onto your rates in council. It's not a realistic option. We heard Darren mention that before as well, about how it would work, and I'm sure Merrick has things to say about it from Macquarie. But in reality, what they've done is they've put forward this great political idea saying you can get cheap loans. What they don't tell you is all the conditions you need to satisfy to be able to qualify for that loan. And what they've done is they've made it pretty much impossible for any owner's corporation to be able to get that loan. So it looks great coming up to an election, but it doesn't actually help you in any practical way. The VBA, the Victorian Building Authority, took action late last year against LU Simon Builders, the same builders of La Crosse, and they tried to compel them to come back to do work to a building, to say, well, you've put cladding on a building, let's come back and fix it. The court found they don't have that power. So the regulatory bodies at the moment simply don't have the enforcement powers to do what we need them to do. That's a big problem. And where does that leave all of you and all of us? It leaves us in a position where all you can do is rely upon yourselves and push forward. In terms of the legal aspects about cladding, there are two issues we have to deal with. One is, what are your obligations? And the second one is, who do we pursue afterwards? How do you get the money to pay to fix the cladding? I'll deal with the first one first, and I'll point out that Section 46 of the Owners Corporation Act imposes a duty on all owners corporations to repair and maintain common property. Section 5 of the Owners Corporation Act imposes a duty on owners corporations to act honestly and in good faith and to exercise due care and diligence. That's really important, because what that means is we can't sit around and wait for someone else to come to our rescue. As an owners corporation, you have duties to your owners and to your lot owners, and to your tenants as well, that you have to fix the building. And I know that's a horrible position that owners corporations are in, and it shouldn't be where we are, but that's the truth. If you get a building notice from council, then you have to take action. You can't simply wait until we sue the builder or sue the surveyor or anyone else to get the money. They run in parallel, the litigation and the obligation to repair. Just because the litigation might take 2 years doesn't mean you will have 2 years to fix your building. You have to take action now. And obviously there are safety reasons for doing that as well, and also insurance reasons, as we've heard. The quicker you fix your building, the quicker your premiums come down. So there are cost savings to that as well. And I'll go on later and I'll explain that it's not the end of the world in terms of how to get funding, and once you get the funding, can we recover the interest on that as well? It is recoverable, assuming the builder is still around. What we do if we get a building notice is we first contact the builder, we try and get all the relevant documentation to say what is the cladding that's been put on the building. as Darren mentioned, we need to know that from a risk assessment point of view, but also to determine, is the building notice accurate? All the building notice says is we've come around and we think there is combustible cladding on your building. That's our visual assessment of it. They then put the onus back onto the owner's corporation to prove that's not the case. So you either go to the builder and you get the results, or you get the specifications. Most of the time, builders are pretty good at giving that to you. Some of the time, they just refuse because they're worried about litigation. And other times, their record keeping is so poor they don't have it anymore. So if that's the case, we then have to do testing. And we heard it's about $2,000 to $3,000 or so. We go and get the testing done, and we determine exactly what is on your building. And once we do that, we report straight back to the municipal building surveyor to actually satisfy the building notice, because you can't ignore him. He's the one with the power in this situation. If we find there is combustible cladding on your building, the question is then, what do we do? Well, obviously you need to fix it. To do that, you engage a fire engineer like Jonathan, and they'll attend normally your committee meetings or your AGMs, and they'll take you through that process of what needs to be done. Generally speaking, it's not always necessary to replace all of the cladding. We've heard Jonathan give examples of what might be done with sprinklers, with wall wetting sprinklers as well specifically. The Canon technology is looking to investigate further. There are other options that might be available. So it might not be a case of, okay, we've got to spend $10, $20 million totally stripping off cladding and redoing it. There might be cheaper options and better options to do that. You need to first know what it is you have to do. Once that has been done, then you have to make an application to the Building Appeals Board to get confirmation that that is acceptable. And I'm not going to go over it again because Jonathan spoke about it, but what he essentially said was, if you go to the Building Appeals Board, they will determine, is that solution that you're putting forward acceptable? And if they say it is and you do it, it means no one can come back at you later on. And that's really critical, because what we're seeing, if you look at the history of cladding, is people thought what was on the building was fine. And no one picked up on it. And then later on, they're coming back at you now and saying, no, fix it. We don't want that happening again. So going to the Building Appeals Board solves that problem. Once you've got the determination, probably the most important thing you can do in terms of cost savings is put it out to tender. Don't just go and get one quote. And I say that because obviously you want to get the cheapest option, the most cost-effective option, but also because if it does come down to litigation against the builder, we need to be able to prove that we took reasonable steps to verify those costs. And the best way to do that is to go and get comparative quotes. Okay, so let's say you've done your tender, you found that one builder is going to be $2 million cheaper than the other builders, and you want to go with them. How do you formally go about signing that contract? The problem you then face is the Owners Corporation Act puts these hurdles in front of you. You can't just go as a committee, resolve to do it, and sign a contract. It's not that simple. Almost certainly the works that are going to be undertaken will constitute a significant alteration to common property, because it is the exterior of your building, or at the very least upgrading works, because a building permit will be required. If that's the case, you need to pass a special resolution, which means you have to go to all the owners. You have to get 75% to agree to it, or at least 50%, with no more than 25% against. That's not an easy thing to do. I can tell you for lacrosse, that took us about a month of calling every single owner. There's 500 of them to get that through. We held information evenings with agents, with owners, tenants, everyone. There was a considerable effort put in just to get that resolution passed. And if ever there was a building where you'd think that it would be quite easy to pass a special resolution to get a building fixed, it's one where they've had a fire already. So we did pass it there. But what I'm saying to you is it's not a fait accompli that you're going to pass it. And the biggest hurdle you find is that owners come to these meetings and they rationally say, we're the victims. Why should we now have to go and pay for this? Why should we sign a building contract? Why doesn't the builder come to the party? And that's a real emotional roadblock to overcome. But you have to do it. There's no two ways about it. The next issue that comes up is funding. How do you pay for it? Again, you'll need a special resolution. You wrap them into one special resolution. So you don't do it twice, but they both come up in discussions. There are really two ways to fund it. One is special levies. So every owner tips in. So it could be $20,000 an owner. The problem with that is what are the chances that every single person has $20,000 spare? It's not likely to be a case in most owners' corporations. That's why probably in 95% of cases I'd suggest that taking out a strata loan is the way to go. That guarantees you'll have the money. It means you don't have to wait for other people to pay. Because even if you do a special levy and you have 80% of people paying, well, you've still got a 20% shortfall that somehow you have to pay the builder. By doing a strata loan, you're guaranteed to have that income. Now, I'm sure Merrick will speak about that later, what your options are with regards to that. But generally, the banks have been quite good in lending for cladding rectification. I've spoken about cladding rectification loans quickly. I don't want to go into detail other than to say they're not practical, they're not going to work. I wish they were never put out, because the question I get asked every day, about 12 times a day, is someone calling me up saying, well, how do we get this loan? The answer is, you can't. No one has got it in all of Victoria, I don't think, yet anyway. So it'd make my life a lot easier if you all just forgot that it existed. It's just not an option. If you can't pass a special resolution to get the funding or to sign the building contract, then you make an application to VCAT to appoint an administrator. The administrator can be appointed for 1 day even, simply to pass those resolutions. So the administrator gets the powers of the owners' corporation. They would have the power then to enter into a loan, to enter into a building contract, and really it's the only way to resolve the issue, if it gets to that point. And we obviously hope that it doesn't get to that point, but we're starting to see a few cases where that's becoming necessary now, or pretty close to it. The next part of the legal aspect is, how do we recover money from other parties? And that's probably what you're more interested in. Now, Section 8 of the Domestic Building Contracts Act imposes warranties on builders. So builders have to give these warranties by law. For example, they have to warrant that all materials are fit for purpose, that they comply with all the laws and regulations, that they carry out their work in a workmanlike and professional manner. Clearly, if there's combustible cladding on a building that's not compliant, it is a building defect. Those warranties have been breached. And if you look at the Lacrosse case, that's what we sued under. It's a breach of those warranties. It's actually no different to any other building defect. So if you were suing for a leaking balcony, you would be under the same warranties. It's simply a bigger type of defect in terms of the monetary value. But it still is just an ordinary building defect. Now, the first step that we do is you obviously write to the builder. You say, hey, you put this on the building, please come back and fix it now, or pay us. We're getting a few different responses when we do that. Some builders, to their credit, are pretty good about it. They're coming back and they're saying, you know what, we put our hands up, we did the wrong thing, and we're going to now come and fix the building for you. And that's the best case scenario. Most builders, though, are coming back and saying one of two things. Either we built this building in accordance with plans and specifications, so we've done nothing wrong, or they're saying, yes, there's a problem, but it's not our fault. It's the surveyor's fault who didn't check properly, it's the fire engineer, it's the architect, it's everyone else, but it's not the builder. And they might have a point in that, but it doesn't stop the fact that the owners' corporation has to sue the builder, because that's the person who owes them the warranties. Now, if the builder doesn't respond in an appropriate way, we make an application to the DBDRV. That's another hurdle that was put in front of you in April last year. It's a conciliation process. The good thing with this is that any time we mention cladding to the DBDRV, they panic and they simply give you a certificate saying it's not suitable for them. Once we get that, the next step is VCAT. But again, another hurdle. To go to VCAT, you need to pass a special resolution. So again, the same hurdle as before. You need to get all the owners, or 75%, on board to support the litigation. If you can't do that, and usually you won't be able to do that in circumstances where you have a large proportion of owners being foreign investors, and they just don't, they're not involved, they're not here, they're overseas, they don't reply. It's not they vote no, they just don't vote at all. When that happens, we get one or more owners, and what they'll do is they'll commence the proceedings on behalf of the Owners Corporation, and they will utilise a specific section in the Owners Corporation Act that allows them to then apply to bring the case on behalf of the Owners Corporation and to substitute the Owners Corporation in for them. And that's how we get around that issue. So there are ways to get around these hurdles. Once we're in VCAT, we don't just claim the cost of recladding, you also claim the insurance increases, so your premium increase. So if you've had this cladding on your building and it's been known for 2 years, and you've paid an extra $400,000 as a result, then you claim that back. We claim that against the builder. We also claim the interest costs of the funding. So if you take out a strata loan, you've paid $100,000 in interest, then you're entitled to claim that back from the builder as well. If the matter goes to VCAT, don't expect it'll be a quick process, unfortunately. The builder will almost certainly join other parties. So they'll join the surveyor, the architect, the fire engineer, project manager, anyone else they can join, they will. And what they'll be arguing is, yes, they may have done the wrong thing by putting it on the building, but they were told to do it, and the surveyor failed to check it. And there is merit to that argument. And if you look at La Crosse, we don't have a judgment yet, but that's exactly what we had 6 weeks about in VCAT. I'm not going to place my bets as to what the outcome will be, but I think it's fair to say that every single professional in that case will cop some form of liability. And the problem for owners corporations is that slows down the process. If it was just the builder and they were clearly the number one person that's going to be responsible, and they didn't join anyone, the time taken to complete the proceeding would be halved, if not more. And it'd be a lot cheaper to run. But because all these other parties are involved, the fight doesn't become with the owners corporation, it becomes a fight amongst themselves, which unfortunately the owners corporations get dragged along with as well. And they're forced to take that time, which means it takes longer to get your money. And that's why I always say, before you actually take the decision to go to VCAT and commence proceedings, and I'm probably the only lawyer in the world to say this, but you've probably got to look at the commercial realities of it. You've got to decide, is it worth going to VCAT? If the cost to you in legal fees is going to be $200,000 and you're fighting over $100,000 to $200,000 or even $300,000, it's probably not worth it. If you're in a large building where it's going to cost you millions of dollars to repair, then absolutely you'd spend the money. But it's not simply a case of saying, we're angry at the builder, let's sue them. I think my view is, look at the dollar value of it. The best case is the builder accepts liability, they fix the building, and then they sue those other parties. That has happened in some buildings. With the hospital it happened, I know. Unfortunately, for some reason, builders aren't doing that in general, and it is a problem. The biggest risk that you face, and also one of the commercial risks, is that if your builder goes bust, like Hickory, then you can't pursue them. You can't go after an insolvent entity, so you can't recover from them. So you might go and spend a lot of time and money fighting them, and at the last minute they pull the pin, and there's nothing to stop them doing that. And that's, again, I think it's a failure of legislation. The other issue you've got, and I know most of you will be shocked by this, is there's no builder's warranty insurance for buildings over 3 stories. So that means that if you look at Eureka Tower or any of the big buildings, they don't actually have insurance if the builder goes bust. You can't claim on the insurance policies because they don't exist. If you're under 3 stories, you can. The builder goes bust, you can go after the insurer, no problems. But in most cases with cladding, they're high-rise buildings, so it doesn't apply. This is purely my view, but in terms of what the government should be doing and what options are available to them, because I get asked all the time, how do we fix the problem? There are 3 things the government can do, practically. One is they can remove that exemption for insurance, at least provide some comfort to owners corporations that their buildings are insured. That exemption was brought in after the insurance crisis in about 2002. I think it's probably come time now, we've seen the impact of taking it out, maybe realise the errors of their ways and take out that exemption again. The next thing is we have to give greater powers to the VBA and to the regulators to actually go and prosecute these builders and actually take them to task and force them, more importantly, to come back and fix buildings. Don't put the onus on owners corporations to take that litigation, put it on the regulators, that's their job. At the moment, they don't have the power to do it. And the last thing is, as you saw with the bushfires, the government does have the power to raise money and put levies out on people. And it's not a great situation, and I'm not suggesting that, that's the be-all and end-all, and that's the best way to fix it. But maybe it has to be looked at some form of subsidising owners corporations. At the moment, all that's been offered are cheap loans that are unachievable, and that even if you get the loan, doesn't change the fact that you're the one that still has to pay it back. And to me, that's not a solution. So that's my view, and you can see I probably share your frustrations because I've been living it as well for a number of years.